of exceptions. And, you know, there's some clarification that we just need in this regard. Can an appellate court, for example, hear evidence? Because so many persons reading your piece may just need some clarifications.
Yeah, number one, section 396, subsection 7 of the Administration of Criminal Justice Act 2015, to the best of my knowledge, is not as wide as section 22 of the Supreme Court Act and section 16 of the Court of Appeal Act. Both sections, I mean, I'm talking of the Supreme Court Act and the Court of Appeal Act, were also made by the National Assembly contrary to the provisions of the Constitution. In other words, Section 233 of the Constitution simply provides that the Supreme Court shall, to the exclusion of any other court, hear appeals from the Court of Appeal, while Section 40 empowers 240 of the same Constitution, empowers the Court of Appeal to hear appeals from a High Court, that is Federal, State, FCT High Court, Sharia Court of Appeal, Customary Court of Appeal. But the National Assembly found that that would not be sufficient. Sections were provided in the enabling acts of both courts to empower them to take over in totality the cases, I mean, the appeals brought before them, and then act as a court of first instance, i.e., High Court. For me, that, and they can take evidence. Whereas Section 396 of Section 7 simply says, go and conclude a part-hard matter.
Let's break this down. So if by law a judge elevated to the Court of Appeal cannot sit over a matter at the High Court, what then happens if the next judge that is sitting over this case is then elevated to the Court of Appeal? Can you help us to highlight the problems with the case going de novo or starting again?
What the problem of the case starting de novo is that it's going to be difficult to get the witnesses. We are talking of a 13-year-old case. This particular case started in 2007. There are others that started in 2008. That is 12 years. If you say go and start all over again to assemble the witnesses, you are going before a new judge to get the evidence together. You know, it's going to be extremely difficult. And that was why, in fact, there was a particular case in which both sides have closed their cases. That is the prosecution and the defense. They have led their witnesses. The court now adjourned the matter for the adoption of written addresses so that the judge could give his judgment. But before the next adjourned date, there was an announcement that the trial judge had been promoted, had been elevated to the Court of Appeal. And that was the end of the matter. So we have to start de novo. 12 years running now, the case hasn't made any progress. So these were the reasons, you know, that led to the amendment of, introduction of that section in the Administration of Criminal Justice Act.
Well, Mr. Falana, let me rephrase the question this way. Are you saying, more or less, that the Supreme Court arrived at its decision in the Udogu case in error, far in Korea? But given the fact that this is now... But given the fact that the position of the Supreme Court in that particular case is now the position of the law at this moment, what do you think could be the implications for other cases that could fall under the same category? Do you see more persons going to court to say, well, this is the position of the law, and our own case should also be treated in the same manner?
With profound respect, I would think that the Supreme Court was not availed the opportunity to consider this section in its entirety. For instance, if the attention of the court had been drawn to Section 22 of the Supreme Court Act or Section 16 of the Court of Appeal Act, that not only allowed them to continue both appellate courts, to continue cases pending in the lower court, but to take over and take them as high courts, I'm sure the court will have had a different thinking. Secondly, the court challenged the fears given by the President of the Court of Appeal to the Justice Mohammed Idris to go down to the federal court to conclude the case. I've also asked the question, where there's not in the Constitution that the Chief Justice can give a fiat to a judge to go and sit over a judicial or administrative commission of inquiry set up by a state governor, because the decisions or the recommendations of the commission of inquiry, you know, are lower in the hierarchy. I mean, if you look at the recommendations, what I mean is that once there is a white paper and you want to challenge any provision of the white paper, you have to go to the High Court. No matter, notwithstanding the fact that the commission was headed by Supreme Court Justice, as far as our law is concerned, that commission of inquiry is an inferior tribunal, inferior to the High Court. Secondly, our Chief Justice also gives fiat to judges to go and serve outside the country. Again, when you look at the Constitution, from Section 1 to Section 320, there's no provision for posting a judge outside Nigeria. And so that is why we have to look at this judgment in all its ramifications and the implication for the judicial system. For instance, I have confirmed that over 60 cases are going to be affected. In other words, whereas the president of the Court of Appeal had given fiat to judges to conclude over 60 cases, we are now going to have a situation whereby those cases will have to start de novo. It is very expensive for any state. And this judgment for me would have been okay if anybody has shown a miscarriage of justice. But in this case, the appellant and his co-defendant and ask for the fiat. Please give them a fiat to conclude our case, because they couldn't allow the criminal case to hang over their heads like a sword of Damocles indefinitely. Now, if you are now going to ask a court to set aside a judgment in a criminal case, you have to show primarily that there was a miscarriage of justice. There was none in this case. And that is why some lawyers have described this case, this judgment, as a technical escape for, you know, the two people involved.
Mr. Falana, thank you for expressing your views in that regard. Let me ask you something else. Now, some critics of the judgments have also brought up a question saying, or an argument saying that, to be honest with you, Orji Uzokalu wasn't the applicant. It was actually his co-defendant, as we know, Ude Jones Udeogu, and therefore this ruling does not apply to him. How do you respond to that?
Well, technically speaking, it does apply to him because it's going to take advantage of it. But it cannot be a basis, the judgment cannot be a basis to get him out of Kuje custody, prison custody. He now has to use the judgment to go down to the Court of Appeal, where he has his own appeal pending, you know, by letting the court know on the doctrine of stare decisis that, oh, a higher court has taken a decision, that is the Supreme Court, which is binding on all authorities and persons in Nigeria. Therefore, on the basis of this judgment, allow my appeal and let me go home. That's what is going to happen in this case.
Well, Mr. Falana, Kenneth Ikone, SAN, had argued that, look, what the Supreme Court has done is just to rely on technicality, rather than attempting a purposive and more liberal interpretation of Section 396 of Section 7 of the Administration of Criminal Justice Act, which, in his view, was introduced to correct, to correct a certain mischief, the non-conclusion of cases. But now, with what we have before us, what will you recommend? Will you recommend an amendment of Section 290 of the 1999 Constitution to accommodate what is provided for in Section 396 of Section 7 of the Administration of Criminal Justice Act?
I fully agree with the learned senior advocate of Nigeria, and that our judges will have to look at the mischief that laws are meant to cure and then do justice in every given case. But my own worry, and I've expressed this publicly, when it comes to the rich, the bourgeoisie, the law is rather bent to accommodate them, and that is why our courts resort to technicalities, which is not very good because we now have a situation where we are establishing two criminal justice systems, one for the rich and one for the poor, in a country where there are no resources to prosecute cases indefinitely. You cannot afford to resort to technicalities. In this particular case, this is the second time these two cases have gone to the Supreme Court. The Supreme Court has held again. Go back and start all over again. So we're expecting that the judgment will go back to the Supreme Court a third time. No country does that in the world. And that is why we have to move with the rest of the civilized community. On this one, there are two ways of going about it. I do hope